of the phrase to get rid of me. Nobody wanted to get rid of him. We were exercising our rights to have a fair trial, which is a much more serious matter than getting rid of some individual. Those rights to the fair trial, as Mr. Dana has correctly pointed out, caused the postponements from around about April to the time your Lordship handed out your ruling as such. Now, our position is this. The issue of the recusal or non-recusal of Mr. Downer is obviously intertwined and interlinked with the commencement of the trial. That goes without saying. That being the case, my Lord, the NPA has two options. Either it insists on the commencement of the trial on the dates that have been proposed without Mr. Downer, with some other prosecutor. That's an option that's open to it, which has been open to it, by the way, all along, despite the false accusations of so-called Stalingrad and what have you. If the NPA wanted to call our bluff, as it were, they should have just said, oh, okay, we are using this so-called delaying tactic, we'll just put another prosecutor. The trial would have been finished by now. But they can't have their cake and eat it. They can't want to commence the trial and also retain Mr. Downer. They must choose one of the two. And let me explain, my Lord. The application for the recusal of Mr. Downer, just as it caused the postponements before, as Mr. Downer correctly pointed out, is still alive. And what do I mean by that, my Lord? I don't have to lecture your Lordship about the implications of Section 18 of the Civil Procedure Act, or just the normal consequences of an application for leave to appeal. So in law, we are in exactly the same position that we were in before your Lordship granted your Lordship's order, because that is the legal impact of the filing of an application for leave to appeal. Now, the grievance, I think, let me put it that way, and it's not exaggerating it, of former President Zuma is the fact that he has now instituted processes to try and reverse your Lordship's decision. And quite frankly, those processes, at least until now, have just been ignored. Nothing has happened. And he felt very strongly about this, my Lord. I think I don't want to put it higher than that. And actually gave us instructions to take certain steps, but we advised against those steps and said the best thing to do would be to come here, discuss this matter with the court, find out what the position is, and then thereafter he can exercise whatever rights might be available to him. But let me summarize what his position is. His position is that he's entitled to the reasons, like everyone else. Again, your Lordship knows all the cases. I don't have to cite cases. That courts are compelled to give reasoned judgments so that citizens can know why they have certain orders adverse to them made against them. It's just a constitutional right that flows directly from Section 34 of the Constitution. That you, and the case I have in mind, my Lord, is Mpahlele versus FNB. It's a 1997 2 SA, I think page 377. It's a decision of the Constitutional Court, paragraph 12.
Page again?
Mpahlele.
Yes, the full citation.
Oh yes, it's 1997 2 SA 377, 677.
Yes.
Paragraph 12, I think Goldstone HA said that the duty of a court to give reasons for its judgment is a concomitant part of Section 34 of the Constitution, the right to a fair hearing and so on. The Lordship knows that. But he made a further observations that that duty also vindicates, not only vindicates Section 34, but also gives the citizen the right to know why they have had an order against them. But more importantly, he said, which is relevant to today, he said that right, or rather the acquisition of that right, also is helpful to the Court of Appeal, because the Court of Appeal would otherwise not know what it is dealing with. And that then brings the matter directly to where we are, which is the linkage between, we've spoken about the so-called two issues, the linkage between those two issues. So the reasons give you the ability to appeal. And that appeal is itself a self-standing right. Again, your Lordship knows this, that although the right to appeal in civil matters is, if you like, implied in Section 34, and our courts have accepted that. But when it comes to criminal matters, the right to appeal is not implied. The constitutional drafters decided to spell it out in Section 35.3.0. 35.3.0 of the Constitution. And why is that? It is because the right to appeal in the criminal context is a fundamental right which needed to be spelled out explicitly by the Constitution. Now we're in a situation where we are, our hands are tied in that we are unable to exercise those rights. And I may add, my Lord, at least to the credit of the NPA, when they received our notice, as your Lordship knows, then they filed their notice to opposition and put the grounds. So in legal terms, that means we have what is called a dispute. We've put our grounds, they've put their grounds for opposition, and that's a dispute. And Section 34 says that every citizen has a right to have a dispute resolved before a court of law, an impartial court of law, at that. Now, so that's where we are, and therefore, my Lord, we would humbly request the court to grant former President Zuma his rights to be given reasons for the adverse decision and his right to appeal it. And that's not strange, my Lord, because the parties went into the trouble of pleading and so on, counter pleadings. Your Lordship went through the trouble of listening to the arguments, and your Lordship came to a determination. That's all very well. But we are entitled not just to the determination, but to the detailed reasons, so that if we are happy with the reasons, we might be, then that might be the end of it. But if we are not happy, then we would exercise the other right. So, and my Lord, this court is familiar with this. This is what happened here in relation to the Section 106 matter. And this is what happened in relation to the recusal application of Judge Kuhn. So it's not something that's just like some new procedure that we're inventing. And I want to end it with this example, my Lord. If you remember when Judge Kuhn's application came, or rather recusal came, he indicated his discomfort, and we supported his recusal. The state opposed it. Well and good. Again, then there was a dispute. And therefore, it was argued, and then he came up with his judgment shortly before the beginning of last year, which eventually ended up with your Lordship now being settled with the case, to cut a long story short. Now, imagine, my lord, if the Judge Kuhn or the state, which was the aggrieved party then, because the judgment was theoretically against them. If the state had said, we want to appeal Judge Kuhn's judgment because we don't believe he should have recused himself, or if he had found against us, we could have done the same thing. And then Judge Kuhn would have had the leave to appeal, granted it or not granted. We couldn't ask him for reasons because he had already given us reasons. Now imagine if in that scenario, Judge Kuhn then said, oh, by the way, can you come in March or April for a pre-trial so that we can set the trial date? That would have been absurd. We would have said, what are you talking about? Because all that is dependent on your recusal or non-recusal. So we're exactly in the same situation. From a legal point of view, the recusal of a judge or the recusal of a prosecutor has exactly the same consequence. Because the so-called pre-trial, the so-called trial to which this is supposed to be a pre-trial, as we speak, is a trial that is run by Mr. Downer, the potential recusee. And so that's really the to just clarify the issue. Just 1 second, my lord. Yes. Oh, yes. Just to explain, so that's the position, my lord, as to what Mr. Downer correctly said, that they sent us documents, we did not respond. And that's really the context, because our client has insisted that we must not put the cart before the horse. Let's start with the horse, then we will deal with the cart. And Section 8, yes, I've already addressed. So, one of my colleagues was reminding me about the Section 18 point, but I've made that point earlier. As the court pleases, my lord. So let me just check.
Yes. Yes. Application for leave to appeal?
What about it?
You are only going to address the issue of the application for leave to appeal once I made a decision on the...
Yes, no, my lord, we didn't come here for any application. We came here for a pre-trial. And we never were told that there's a set down for an application. I think that's not what Mr. Downer was saying as well. Mr. Downer was saying that there should be an order. He was almost suggesting that there should be an order without argument. I've never understood that there was a set down for that. Let me just...
Yes, just yeah.
Okay, I thought maybe it's me. No, my lord. No one has ever indicated to us. We would have, in fact, we would have welcomed it, obviously, because that's what we want. But that's...
Yes, I was under the impression that the two issues that are going to be dealt with are, firstly, the request for reasons, and secondly, the application for leave to appeal, the order of the court.
Yes, my lord. No. To be dealt with in the context of the pre-trial, of the summary that Mr. Downer has articulated. I don't know about Mr. Downer. Let me just check with him. Did you want to run the
Yes.
No. Well, he says he wanted to run the application. Well, in any event, that's irrelevant because we cannot run an application for leave to appeal without reasons. I think that would be... I certainly have never been told that there's a set down date for the application for leave to appeal. That might just be a misunderstanding, my lord. I don't want to make much of it. But the substantive point is that in any event, even if we were told, we would have come here to say we need reasons
First, before
exactly. So that remains our position. As a lordship, just the sequence is really reasons, application for leave to appeal, then we can get into the trial and pre-trial issues. And as we sit here, unless if my attorney...
in the correspondence that...
My attorney assures me that he hasn't had any reasons, or a response to the request for reasons.
Oh, I see. All right. Yes, all right. Let me hear Mr. Downer then.
Yes, my Lord. I apologize.
Thank you, my Lord. Just a few preliminary points in answer, my Lord. First of all, my learned friend develops an argument here today without any indication or notice to the state or the court what he's going to say. My Lord, we served the draft pretrial minutes on the defense and on the defense with an invitation to join in the creation of pretrial minutes with the consent of all the parties. They declined to do so. There's no reason for them to decline to do so. If my learned friend wanted to make the points he's making today, he should have made them in a pretrial minute so that we could all be apprised of his attitude and be prepared to answer whatever arguments he's brought up. And he's brought up new arguments today, which we were not apprised of beforehand. Nevertheless, I'm quite prepared to answer them, and I intend to do so. But nevertheless, that method of litigation, simply to leave it and not even answer the state, not even pay the court the courtesy of apprising the court as the parties are enjoined to do in the Judge President's pretrial minute directive of 2018, to apprise the court of what is going to happen at the pretrial so that everyone is properly prepared, so that the pretrial may be concluded and so that the matter may not be adjourned again for yet another pretrial. And remember, we're in the third pretrial now. We've been trying to get the pretrial going since April. So, my Lord, we take exception to that, and the answer to that is not to grant a postponement, but to deal with the issues today. And I submit with great respect that we are able to address the court meaningfully, and Your Lordship, I submit with great respect, is also able to do so. All the issues are live before the court and have been properly addressed in the papers before the court, even though my learned friend has not seen fit to provide us, as he should have, with his input in the pretrial minute. But we'll leave that then for the moment. My Lord, our answer to the application for written reasons, together with our answer to the application for leave to appeal, is contained in our answering affidavit, which we filed in due course with this court, and is before the court. And we deal with both those issues, both the issue of written reasons and the issue of leave to appeal against Your Lordship's judgment. My learned friend also, just as a preliminary issue, my Lord, fails to accept that as we now here stand, this court has dismissed the second application for my removal. So as we now stand, I'm not removed. There is an application for leave to appeal. That doesn't change the position in this court that as far as this court is concerned, I am, the application has been refused, and the application for leave to appeal I submit can be answered, and it should be answered, as we say in our papers, to be dismissed. If I could then turn, my Lord, to our papers, our answering affidavit, if I could just take a moment to get to it.
Sorry, Mr. Downer, I think Mr.
Yeah.
Yes, Mr. Mpofu.
My Lord, I object to this. We don't want to play games here with the court. I thought Your Lordship was giving Mr. Downer an opportunity to respond to what I was saying as to what is going to happen. He's now delving into responding to an application that has not been moved by anybody. And so I don't understand that procedure. The question is whether if the court is prepared to hear the application for leave to appeal, whether that should happen before or after we are appraised of reasons, have engaged with those reasons, and as I said, we might even decide to withdraw our application for leave to appeal if the reasons are good enough, if we are aggrieved. That's why in our notice, Your Lordship, you'd have seen that we said we reserve the right to expand on our application for leave to appeal once the reasons have been furnished. Yes. So that's really the only issue to be addressed, and not for him to just dive into the actual applications. And I would appreciate it if he addresses, or rather responds to my address on that. But as far as the telling the state what we want to do, or we are raising new argument, we haven't raised. What new argument have we raised?
All right, let's deal with this way, Mr. Mpofu.
Yes.
I'm going to ask Mr. Towner to confine himself to the issue pertaining to reasons.
Yes.
Then thereafter I'll allow the opportunity to reply.
To respond. I'm happy with that, my Lord.
Yes, thank you.
I hear you, my Lord.
Yes.
My Lord, could I just draw your court's attention to this issue of whether we were due to move the application today? If one looks at the pre-trial minutes of the 23rd of April, 2024, which is cited in today's pre-trial minutes on page 3 in paragraph 14. So look at today's pre-trial minutes, that's the 29th of August, where we cite the previous pre-trial minutes, and we say that on the 23rd of April, when the trial was due to start and the matter was then adjourned for a pre-trial, we filed a notice of opposition. Then, to quote the pre-trial minutes, to be moved at the hearing on 17th of May 2024. So it is indeed a live issue. We gave notice that we were going to move it on the 17th of May. Today is an adjourned hearing on the 17th of May. So my learned friend is incorrect to say that we did not give notice that at the pre-trial hearing, which is today, we will be moving for the application to be heard. And the fact that he didn't engage with us and with the court in the pre-trial minutes is not of our doing. So he has notice. Today is to move the application, but let us then begin, in accordance with your lordship's order, to start with, has the court given written reasons? If I could then move to our affidavit in answer to Mr. Zuma's application for leave to appeal. We deal with this issue, if we could just get to the right place, my lord. I'll be with your lordship in a moment. And first of all, my lord, just to make the point that this method of litigating without notice, without engaging with the state in the pre-trial minutes, and with, no doubt prefaced, as my learned friend says, with a further application for a postponement, is in accordance with what has already been found to be by this court, full courts of this division, and the higher courts as an abuse. We make that point at paragraph 4 of our application. My lord, I'm getting to the point. My learned friend could just give me and stop interrupting me.
My lord, I'm not going to take that kind of abuse from Mr. Downer. I have a right to object when I feel that there's an objection to be made. And he has assured me that he'll get to the point, and I sat down. So I'm not going to be abused by him gratuitously. Thank you.
My lord, I shall proceed with my argument. Let's get to the point, my lord. At paragraph 10, my lord, of our affidavit, at paragraph, I'm getting to it now. As it pleases the court, at paragraph 7, we say that it was on this basis that your lordship ordered that the application for the removal of me as the prosecutor in the criminal prosecution of Mr. Zuma and Tali's was dismissed with more substantial reasons to be incorporated in this court's judgment at the conclusion of the trial. And your Lordship further clarified to Mr. Zuma's counsel that the substantive reasons for the ruling will be incorporated in the court's judgment at the end of the trial. We say that the court has a discretion in these matters when the interlocutory rulings given, that the court gives reasons in the discretion of the court, which may not be full reasons, but that the court at the end of the day gives full reasons during the judgment on the merits, if necessary, and that is in the discretion of the court. The fact that in different circumstances His Lordship Judge Kun might have chosen to give full reasons in a different application at a different stage of the proceedings is no precedent for this court to follow to say that full reasons have to be given. And we say at paragraph 6, if I could just return for paragraph 6, we say at paragraph 6, we say, it is not correct that your Lordship did not give reasons for your Lordship's ruling on the 20th of March 2024. This court, my Lord, informed counsel that the court had decided in the interest of justice and in accordance with section 173 of the Constitution to incorporate reasons for the order that would follow in this court's judgment at the end of the trial. And the court, my Lord, provided reasons in your Lordship's judgment, including inter alia the following. Paragraph 6.1. The question which required, this is what your Lordship's reasons then included, and these are your Lordship's reasons. The question which required determination was whether the retention of me as the prosecutor in the present matter would infringe Mr. Zuma's fair trial rights, entrenched in the Constitution. Having considered the 4 pillars which were put forward in my learned friend's papers in the application for leave for removal, Mr. Zuma raised in support of his second recusal application the very same issues in this application for leave to appeal, which have already been decided by our courts, as explained above. Your Lordship emphasized that having had regard to the submissions made by counsel, the relevant case law, and most importantly, the 4 pillars relied on by Mr. Zuma, this court was not persuaded that Mr. Zuma succeeded in establishing that the retention of me as the prosecutor in the matter could prejudice his right to a fair trial enshrined in section 35(3) of the Constitution. And then, as I've said, it was on this basis that your Lordship ruled that the application should be dismissed. So it is not correct that no written reasons were given. It is correct that written reasons were given. The fact that my learned friend might be dissatisfied with the nature of those reasons or that they were too short is an issue which can be taken up on appeal. It is not it is not an issue which is terribly live before this court, except that my learned friend has now launched a substantive application, and that substantive application needs an order. But the order is already there in your Lordship's judgment, previously given on the merits of the application itself, and therefore the court's order is simple, what the court can order today, without any further reason for postponement or further argument. Your Lordship would simply refer to your Lordship's judgment with great respect and say that reasons have already been given, and therefore the application for reasons and or for further reasons is dismissed, because your Lordship has already ruled on it, and in effect your Lordship is actually functus officio. So the order is just a matter of course. So therefore it need not be postponed, and your Lordship is at liberty, I would submit, should your Lordship feel so disposed, to give such an order today without any further postponement of the matter on that issue. Furthermore, my Lord, the matter is, because of the development of this matter, the different circumstances and the rulings of the various courts, the imperative for this trial to start without any further imperative relating to this issue is just as strong as it is on the merits of the application for leave to appeal itself. So in that respect, that the mala fides, the lack of good faith which have been found by the various courts, including this court, full courts, and the Supreme Court of Appeal, and by implication the Constitutional Court, all those issues were not issues which had been crystallized by the time that His Lordship Judge Kun, in his wisdom, decided to give reasons in a previous application. So it is of no application, I submit to Your Lordship now, and Your Lordship is at liberty to say that, reasons have been given and the application is dismissed. If just one final point on that, I seem to remember, my Lord, I haven't got it here with me because I didn't have notice, but I think there was correspondence between Your Lordship's registrar on copy to us and Your Lordship by my learned friends before the substantive application, requesting reasons informally. And I seem to recall that Your Lordship, in fact, sent an informal email or letter, we can get a copy of it in due course, to say that those were Your Lordship's reasons. So if that is so, if my memory serves me correctly, and I think it is, that is further reason why Your Lordship is at liberty now to simply issue the order that no further reasons will be given, and we can then move on, if I must now confine myself to that issue, to the other issues as Your Lordship directs. May it please the Court, my Lord.
Yes, thank you, Mr. Yes, Mr. Mpofu.
Sorry.
Lord, let me start. I think I understand what Mr. Downer's problem, or where we are not finding each other, is now. So I'm indebted to Your Lordship for having given him that opportunity. My Lord, this is what it looks like, my Lord. Firstly, let me just put Mr. Downer at ease about, he's saying we did not apprise the court of what we require. We don't apprise the court by phoning the court or sending emails or whatever. We apprise the court by filing notices. That's what the rules say. So we filed a notice requesting reasons. We filed a notice for application for leave to appeal. That's how lawyers communicate with the court, by process, legal process. And that's what we did. So the court knows, and Your Lordship has indicated more than once, at least today, how the sequence of events should follow. And therefore, if one follows the sequence of events mapped out by Your Lordship, we are now at issue number 1, which is the issue of reasons, which Mr. Downer has addressed. Well, this is our response to this. Mr. Downer is just being downright disingenuous, because he stood up here, he properly explained the position as indicated in his draft notice, draft minute. And now he is shifting his position. He now wants to move an application. If he was here to move an application, as he says, why did he not move it before I spoke? He's only moving it now because he wants to opportunistically take advantage of a situation of the misunderstanding that we spoke about as to what is the purpose of today. Is it a pre-trial, or does it also, and I can assure Your Lordship that seems, at least to me, between us and the court, to be a genuine misunderstanding. That's neither here nor there, because that can be dealt with. My Lord, if Mr. Downer was here to move an application, as he puts it, he knows what to do. He would have served us with heads of argument. We would have served him with heads of argument. We would have given those heads to Your Lordship. We couldn't just come here with senior counsel on all sides to just talk without Your Lordship not even knowing what is the ambit of the issues, what cases are being relied on, and so on, the usual manner. And if he had come here to move an application, as I say, he would have moved it. He can't come here and try to move an application from his opposing affidavit. And it's not true that their notice was to move an application. That's just false. Because if you go to page 1 of the state's notice of opposition to Mr. Zuma's notice of appeal, It says, kindly take notice that at the pre-trial hearing set down on 17 May, the state intends to oppose, not to move, like he was saying now, the first accused application for leave to appeal. Now, it's not for Mr. Downer to set down an application on a particular day. If on the 17th of May, the the application for leave to appeal was set down for that date, then of course it's their prerogative to oppose it. But, my Lord, believe me, that has never been our understanding, that the pre-trial is kind of rolled into one with the application for leave to appeal, without reasons, no how. That procedure, I've never heard of it in my experience. And so the snatching at the bargain and moving as we go along, Mr. Dana, at the slightest provocation, always comes with heads of argument about even when they are not necessary. Why would he, coming here for two substantive applications, just rock up and make an address without any reference to any authorities? It's just not true, my Lord. Besides, the lie in this approach is as follows. Let's assume in his favor that he came here to argue the issue of reasons, for argument's sake. Then your Lordship would have listened to both parties and made a ruling on that issue. Then how can he, in the same breath, say he's also here for the application for leave to appeal? Because that let's assume your Lordship agreed with us and then gave the reasons. Then what would happen? The next 5 minutes we are ready to argue an application for leave to appeal. Obviously not. There's no such legal procedure that Mr. Downer can point us to. So it's just a complete disingenuous way of litigation. But be that as it may, my Lord, the law is not what Mr. Downer is telling us. Remember, my Lord, one of the issues in the application for leave to appeal, which will be debated in due course, is that Section 316 of the criminal procedure doesn't apply. Fair enough, they can make that argument. But surely we have a right then to make the counter argument. Surely. And I'm not arguing the point, my Lord. I'm just demonstrating the fact that there are things to be debated by both parties, and the court must pronounce, and then we move on to the next stage. So let me just give your Lordship a taste of what we are talking about in regard to the leave to appeal. Your Lordship knows that Section 316(1)(a).
Mr. Mpofu, I'm now dealing with the application for leave to appeal.
No, I'm not, my Lord. That's why I made that qualification. Believe me, I'm not. I wish I could. No, I can't, my Lord. I'm simply just demonstrating. Please, my Lord, if your Lordship bears with me. I'm saying their position is that you must be convicted of an offense and so on. We know. Our position will be that when that day comes, that when that section says that the court must give leave to appeal against such conviction or against a resultant sentence or an order. Yes. And your Lordship knows that debate. It's been going on for. So our position is that yes, you can ask for leave to appeal against a conviction. Yeah, of course you can ask for leave to appeal against a sentence, but you can also ask for a leave to appeal against an order. And that is why Justice Kuhn.
My Lord, I must object if my learned friend would give way, similarly to the way I gave way to him. I don't understand the argument now. We're dealing with the issue, should your Lordship now give an order and the terms of the order and the procedure relating to the order, relating to written reasons. The argument which my learned friend is now proceeding with doesn't address that issue. So just as he objected against me seeking to take it further,
Yes.
I object to him taking it further.
Yes, I agree with
Ma-
Mr.
no, I agree with Mr. Down as well. My Lord, I've made it clear. I'm not addressing
The issue
the
of,
argument now. Yes, I'm simply making an illustration that the matter is not as simple as Mr. Downer thinks it is. It's a matter that is going to have to be, even that issue, that's going to be debated in the application for leave to appeal. I'll leave it at that because I don't want to create an unnecessary debate. The simple point I'm making, my Lord, is that all these issues are going to be debated in good time when that time comes. For now, our position is very simple. That I mean, Mr. Downer is telling this court that the following: having had regard to the submissions made by counsel, the relevant case law, and most importantly, the four pillars, he was not, my Lordship, not persuaded that Mr. Zuma's application must succeed. He calls that a judgment. Honestly, well, if judgments were like that, our law reports would be very easy to read. This is an order. How can you have parties that have pleaded to thousands of pages, have put legal arguments, cited many cases, and then an order is granted, and then you call it a judgment? It's obviously not a judgment. So if I were Mr. Downer, I would argue...
And just to add to that, for the sake of brevity, Mr. Mpofu, I specifically indicated that reasons will be incorporated in the judgment.
Your Lordship has taken the words out of my mouth. That if I was going to say, if I were Mr. Downer, at least I would argue along those lines that the reasons are outstanding and they'll be given at the end of the trial, and then the debate would be at that level. But you can't come here and try to pretend that this is a reasoned judgment. I mean, that's just ridiculous. Because Your Lordship made it clear that Your Lordship knows he couldn't have just ignored all the cases that were cited. It's a question of when. Now, our position on whether or not that should be the case, my Lord. If I can just refer Your Lordship to. I promise it won't be long, my Lord. It's at 31-12 of Dutoy. It says, yeah, the heading is leave to appeal, of course, before conviction or imposition of sentence. The first paragraph just states what I've already said about the rights, Section 35(3)(0) of the Constitution and so on. And then here's the important part. It says, in exceptional circumstances, however, leave to appeal before imposition of a sentence, and I suppose conviction as well, may be granted. Essentially, this will be limited to situations where it is in the interest of justice to entertain an appeal before conviction. And the cases are S versus Western Areas, 2005 1 SACR 441, SCA Zweni, the well-known Zweni case, and S versus Zuma, that's the judgment of
Kunje.
Of Kunje, yes, which has now found itself in the academic. So, again, I'm not arguing that point now. I'm simply clarifying that the position of Mr. Downer is untenable. Remember that, fortunately, the position of Mr. Downer is on paper, so he can change it now as much as he likes. But the position is captured in his notice, and he says that there should be an order granted and then 2 orders granted. But how can you have 2 orders granted without legal argument? And how can you have those orders which are in a way not symbiotically, the one depends on the other. In other words, the leave to appeal depends on the reasons, all granted as if it's just one application. So, my Lord, we're not seeking any postponement. I heard Mr. Downer talking about seeking a postponement. All we're saying is that we should be put in a position to deal with both of those issues, the issue of whether or not we're entitled to reasons, as well as the application for leave to appeal itself at the appropriate time. And in our respectful submission, that was neither of the parties, if you use this as the evidence, came here under the impression that that appropriate time is now. That's.
Sorry, before you switch, Mr.
Yes, ma'am.
Mr. Mpofu, can you refer me to any particular authority that obliges the court to give reasons when the trial has not been finalized?
Yes. Okay. My Lord, I'm saying this, I've actually given your Lordship those authorities, but let me unpack our submission very succinctly.
Those authorities deal with application for leave to appeal,
Yes.
and it says that those authorities, I think the authorities who gave me now deal with exceptional circumstances where the court can grant leave to appeal
Yes.
in instances where the matter has not been finalized. Am I right?
Yes, my Lord, of course. In other words, even on the interpretation of the state, it would be the exception to the general rule. Yes, no, we're on the same page, my Lord. Let me put it like this, my Lord. In our respectful submission, the right to appeal, which obviously includes the right to leave to appeal, goes symbiotically together with the right to reasons.
I see.
Because you can't, an appeal against what? So, right?
Just a moment. So, yes,
Yes.
I follow the argument. Right now, you are stifled. You can't do anything because you don't have any reason.
Absolutely, my Lord. So it is cold comfort. It would be an empty right to say, oh, you have the right to appeal, but we are going to withhold the reasons. That's the same as denying someone a right of appeal, because it's like a pretend right. You say, oh no, you can appeal, but I'm not going to give you the reasons. So the one, that's why I was using that metaphor of the horse before the cart, or the cart before the horse. And so if the position of the state is that the reasons are not due, but the application for leave is due, then we differ with that vehemently. And our position would be this, my Lord, that your Lordship, particularly on an issue like this, my Lord, your Lordship is quite correct. I mean, if the court decides, look, we're going to sit at 11 o'clock and not at such and such a time, I'm making that ruling. I can't say, well, I differ with you, my Lord, I want reasons and I'm going to appeal and so on. So there are those types of matters, of course. That's why exactly the wording of exceptional circumstances is used. But, my Lord, these are quite self-evidently those exceptional circumstances. Why? Because of what I said earlier. Because the question of the recusal or non-recusal of Mr. Downer is but intricately and inextricably linked with the so-called trial that was supposed to be in a pre-trial about today. It is that simple. It's not an issue because what is the opposite, my Lord? The opposite is that we must be appealing and making an application for the recusal of Mr. Downer. But at the same time, go through a 6-month trial with Mr. Downer. What is that? The very same person who is the subject of the ongoing appeal, at the end of which might be found that he should not be here. Because unless if he knows something we don't know about the Supreme Court and all the other courts, nobody, not your Lordship, not me, not anyone, knows what the outcome of that appeal is going to be. So let's say it's 50-50. If the appeal says Mr. Dana stays, he must stay. But if the appeal says he must go, he must go. And what then would be the logic of running an expensive trial when there's a 50% chance, and I don't want to put it higher than that, that Mr. Downer is not the right person to prosecute the case? It's illogical. That's why I made that example about Judge Kuhn. Because he would have then said, okay, I know you've appealed my recusal, but let's get on with the trial effectively. How would he do that? Because we would say, well, we'll get on with the trial with you, and then somewhere in 2 years' time, it will be found that you should have recused yourself. Then what would have been the point of that exercise? It's completely illogical. It can't work, my lord. The one thing literally depends on the other. That is why your lordship, when your lordship got into this case, postponed the matter so that he, your lordship, must first make the decision on Mr. Downer. That was the logical thing to do. Otherwise, your lordship would have come here in February, March, I can't remember when your lordship assumed the case, and said, well, let's get on with it. And I would have stood up and say, well, my lord, there is the issue of Mr. Downer's recusal. Your lordship would have said, I'm not interested in that, Mr. Mpofu. Call your witness or whatever. But your lordship didn't do that because it would have been illogical for your lordship to do that. Why is your lordship being asked to do something that he would logically not do when you assumed the case? Because for all intents and purposes, we are exactly at the point. I know your lordship has made your ruling. We respect your lordship's ruling, of course. But the law is that we are now in the position where we need the same judgment, but from a higher court on the issues that your lordship has determined. And we have a right to that. It's not a favor that we're asking. We insist on that right. We have a right to have that matter adjudicated to, if we're not happy with your lordship, we have a right to go to the next court. If we're not happy with that court, we have a right to go to the next one. So what is being suggested here is that, unlike all the people in this country, Mr. Zuma only has a right to hear the ruling on the recusal of Mr. Dana from one judge, and he must live with it forever. Amen. What is that? There's no human being who has a right like that. The reason we have a hierarchy of courts, lower courts, the Supreme Court of Appeal, and the Constitutional Court, is because it is known that judges may err. Judges are the first ones to admit that they may err, and the position might change if another court. Why? I can't understand why Mr. Zuma must be denied of that right. Really, it beats me. And therefore, he has that right, and that right cannot be exercised unless he has been given reasons. Because to refuse to give him reasons is the same thing as refusing him that right. That's our position is very, very simple.
There's something that Mr. Masungu asked.
Okay, sir. It's fair trial rights. We've dealt with that. Yes. As court, please.
Yes. Yes, I need a moment to consider my ruling as metal stand.
As please.
on 16 May 2024, dismissing Mr. Zuma's request for the removal of Mr. Towner as the prosecutor in these proceedings. Having considered submissions made by counsel, I am of the view that exceptional circumstances exist that warrant the grant of the request by Mr. Mpofu. However, due to other commitments, I will only be able to do so either on Tuesday or Wednesday week after next, that is the 10th or the 11th of September 2024. I'm therefore going to request counsel to avail themselves on either one of these 2 days.
As please the court, my lord.
As please the court, my lord, we are available. My lord, do I understand that that's the date for the delivery of the reasons?
Reasons,
As
yes.
the court pleases.
Just a moment.
Yeah, the state is available, my lord.
Right, this matter is therefore adjourned to 11 September 2024, and reasons will be furnished on that day.
As please the court, my lord.
As please the court.
As the court.
Court adjourns.